and welcome. My name is Mark Raymond. I'm the director of the Cyber Governance and Policy Center at the University of Oklahoma. Joining me today from the Center for Democracy and Technology is Mr. Greg Nojeim. Greg is the Senior Counsel and Director of the Freedom, Security, and Technology Project at the Center for Democracy and Technology, which is a non-profit organization based in Washington, D.C. We're going to talk today a little bit about some of Greg's work on the topic of transboundary data requests and what happens when a foreign government requests data held by the United States or tech companies in the U.S. from abroad. So before we get into that, we'd like to invite Greg just to sort of tell us a little bit about his organization, about CDT and the work that they do.
So my organization, the Center for Democracy and Technology, is about 25 years old. We're based in Washington, D.C. We're a nonprofit, nonpartisan group, and we're all about freedom on the internet. We like to say that we're keeping the internet open, innovative, and free. And we're dealing with a lot of tough tech policy questions, and I'm delighted to be here and glad that you're interested in them too.
Yes, absolutely. And I should say that I have the privilege of being a non-resident fellow with CDT and of sort of consulting and assisting and being in the position to learn from CDT as well about some of its work, and have really appreciated the opportunity to do that. One of the things that I learned from you as we were sort of preparing to do the events that we're doing on campus and this video was that for British law enforcement agencies, about 90% of their investigations involve the need to get data that's held by an American tech company. So this would be a situation in which they would be investigating a crime or potential crime, and they would realize that a British citizen or a person in the United Kingdom has a Gmail account or has a Facebook account or Twitter or has used Google Search or some other technology product from the United States. So could you start off by telling us sort of about the nature of this problem of transboundary data requests and what's involved in these kinds of situations?
So it's a growing issue. A lot of governments need data that's being held by U.S. tech companies, and it's central to a growing number of investigations. And right now, the method that they have to use to get it is cumbersome, particularly for content. For content, both of the governments have to get involved, and the foreign government makes a demand. It goes to the U.S. Department of Justice, and then it has to be evaluated there, and eventually it goes in front of a U.S. judge, gets evaluated there. If the judge orders the company to make a disclosure, the company then makes the disclosure back to the Department of Justice, and then it goes back to the foreign government. So it can be a lengthy process. Foreign governments, they are busy investigating crimes, and they are growing, I think, increasingly intolerant of the amount of time it takes to run one of these demands up the current system.
So one thing they might do then is to create their own national level legal regime that would allow them to compel that data from the American company. Are there any other sorts of tools that foreign governments are considering using or are actually using to try and solve this problem?
So one thing they'll try to do is demand that the U.S. company locate data in the foreign jurisdiction so that the foreign government can get the data directly from the U.S. server, or the U.S. company's server right in country.
Those are called data localization laws or requirements.
Exactly. And sometimes they're putting increased pressure on the security of communications. So if they can't get the data from the provider in stored form, well, they want to intercept the data as it's moving. And a lot of times that data is now encrypted, and increasingly foreign governments are demanding backdoors to encryption so that they can obtain the data that way. Some foreign governments are also arresting U.S. executives from companies that haven't turned over data or haven't taken down data according to the local rules. So foreign governments have some tools that they are using to compel U.S. companies to turn over data. And I think the U.S. companies feel like they're in between a rock and a hard place.
So how are they coping with that? What are American companies sort of doing to deal with this situation they're finding themselves in?
They're looking for solutions, and they've gotten one through the U.S. Congress. It's called the Cloud Act, and what that legislation does is it permits the United States Department of Justice to negotiate agreements with foreign governments to permit the foreign governments to make direct demands on the U.S. providers. Certainly, that will speed things up for the foreign governments. From our perspective, though, it creates a lot of human rights and civil liberties risks because there's a lot of governments that don't have the same level of protection built into their regimes that are built into the U.S. regime.
And this could be for nationals of the country making the request, it could be for nationals of a third country, but it could also be for American citizens whose data is sought by foreign governments. Is that correct?
So under this statute, no, it's not. Under this statute, the foreign government cannot demand data about a U.S. target, a person who is either here or a person who is known to be a citizen.
So they would still have to use the existing process, which is based around treaties that are called mutual legal assistance treaties for American persons.
Exactly, exactly. And what's interesting, though, from my perspective, is that there's a lot more difference, I think, between legal regimes than people would come to mind immediately. I think the first country up for one of these agreements is going to be the United Kingdom. They've been negotiating an agreement with the United States for about 3 years now. But in a lot of ways, the UK is different from the US in terms of the amount of proof that a law enforcement official would have to put forward in order to gain access to data. There's different rules about free speech. The United States protects a lot more speech than the UK does. There's rules about the death penalty. The UK doesn't have it, the United States does, and the agreement will put the United States in the position of making demands back to the UK for information that might be in a death penalty case. So it gets complicated relatively quickly.
Yes. And it can get even more complicated if you consider a situation in which, for example, Microsoft might store as part of its normal business operations data about American persons in Ireland. But what happens if Ireland creates an agreement like this with another country, say South Korea, that would then seek to gain access to the data not through its agreement or a potential agreement with the United States, but might seek it under an agreement with Ireland?
So you're adding more and more complexity. I suspect the U.S. company is going to look at that and question where the jurisdiction is for that data. I don't think we want to create a regime where, I guess we are, in a way we are creating a regime where people's data is going to be available to governments without their notice and without their control. And that when you store data with a U.S. provider, you're going to be wondering, hey, what countries can get this data? And you're going to want the rule, I think most people want the rule to be that their own law applies. And the Cloud Act, the statute I mentioned earlier, kind of takes that to heart in saying that when the foreign government demands an American's data, U.S. rules are going to apply.
Right. So what other human rights concerns are raised by these sort of transboundary data requests?
So for example, under current rules, when a foreign government makes a demand for a foreigner's data, that demand basically has to go through the U.S. system. There has to be a showing at some point in front of a U.S. judge of probable cause, which is a very high evidentiary standard compared to what a lot of countries use. That's a good rights protective system. And an independent judge is making the decision about whether that standard is met. That's a good system. Some countries don't have that. They'll have a lower level of proof, and the person who is the decider might not be independent from the investigation itself. So there's a question about whether there will be a race to the bottom in terms of the protections that individuals receive under the new system as compared to the current system.
One of the interesting things, I think, is that in addition to human rights effects, there are potential business model effects, right, in terms of driving people either toward or away from using tech providers or platforms based in certain countries based on their knowledge about what legal and privacy and human rights protections would apply to them by virtue of choosing that platform.
I think a lot of people just don't know, right? When you're choosing whether to use a particular service, do you ask the question, what rules apply? Who can get my data? Or do you just say, hey, this looks like something I'd like to use. I'm going to sign up and use it.
I think right now that's basically the case, right? Especially because for a few of these products and services, there isn't much choice. There might be sort of 2 or 3 different choices that you would have. There are a couple of alternatives to something like Twitter, but Twitter has the biggest reach, and so that sort of constrains the choices that people will make. But it's interesting to think about the future, right, and how this might, how these sorts of international legal rules might not only have human rights effects, but could also either incentivize or disincentivize the development of replacement technology platforms in other countries.
I'll tell you what could make a big difference. Say a U.S. tech company receives a demand from a foreign government, and it complies with the demand and it turns over the data, whether it's under the Cloud Act or another legal regime, and it turns out that the data was being sought for a very inappropriate purpose, you know, right, to persecute a dissident, to find somebody guilty of a crime of insulting the king or something like that. I think when those disasters start coming up and becoming prominent, people are going to start asking, hey, what's going to happen to my data? What are the rules that apply to my data? And if you can't tell me, tech company, whose law applies to my data, I might go shopping somewhere else.
Yes, and that's especially true not only for sort of personal use, but say a company is using one of these services, and say that company is in the business of providing accountancy or consulting or legal services or health services, and they have some kind of regulatory obligation to protect the privacy of their users, right? And in that case, if these rules then open up that data to certain kinds of requests by foreign governments that wind up being abused, that could create difficult legal positions for the company.
It does, and you know, we need to be fair to the companies too. I mean, the companies should not be between a rock and a hard place. The rock is if they make the disclosure that's required by one country's law, it violates another country's law.
Right.
That really is not a good position. I think nobody wants them to be in that position, right? Because as a consumer, you don't know what the rules are. As the company, you don't know what the rules are. And as a prosecutorial entity in any country, you don't know what the rules are. So I think clarity needs to be a goal, but so does the protection of rights. We don't want to move backwards from where we are now in terms of rights protections, just to accommodate the need for speed.
And it seems to me that there are sort of political pressures, right, in countries around the world that are kind of driving us to a position of less clarity and less certainty, right? So countries face a cumbersome process now to get this kind of data, and so they're interested in streamlining that process. But if that happens in a decentralized way, even if you consider only, say, the 2 or 3 dozen largest economies in the world in those countries, right, that still creates, or potentially creates, a great deal more complexity and uncertainty, and that creates difficulties for public policy, but also for business operation, for law enforcement, and for all kinds of different legitimate purposes, not losing sight, of course, of human rights, and the protection of human rights and civil liberties is a major objective.
It's a really complicated area. It's growing more complicated. Part of our role, we like to think, is to try to make this digestible and try to make it so that we have a good rights protecting solution so that law enforcement agencies that are pursuing legitimate investigations get the data they need and people's privacy rights are protected at the same time.
So what would you sort of say to our audience in terms of understanding what they can do to sort of be as aware as possible and to do whatever they can to, first of all, protect themselves, but second of all, to sort of join CDT and its allies in sort of making, sort of public presentations or other sorts of steps to ensure that these kinds of human rights are protected?
Well, thanks for asking. Our website address is www.cdt.org. We do a lot of our work to the public. It's public facing, and people can go on the website and see what we're up to and the problems that we're trying to address. This problem of cross-border demands is certainly high on our agenda. And right now, the U.S. has passed its statute. There will be proposals to have different countries get these executive agreements and be able to make demands. The Department of Justice in the United States is going to be consulting with people who have expertise. So if you hear of a country trying to get one of these agreements and you have expertise on the rights situation on the ground in that country, the Department of Justice should hear from you. In addition, other countries are moving forward with their own initiatives. In Europe, there's a proposed regulation called the e-evidence regulation. It's actually a regulation and a directive that would make it so that European governments could make direct demands on U.S. providers. That's moving through a parliamentary process in Europe right now.
So these are important issues for people to keep in mind as they participate in democracy. As citizens in their own countries, whether that's the United States or another country, people should do all the things that we normally do. They should be in touch with their government and petition their representatives and get involved with organizations like the Center for Democracy and Technology that are doing really important work in sort of making sure that these issues are carefully considered and that we do formulate good, sound public policy that actually achieves the objectives that people need to be able to rely on their governments for.
Thanks, Mark. I really appreciate that. It's been a pleasure to come out and visit with you at the University of Oklahoma.
Oh, well, thank you so much for coming, and thank you so much to all of you for watching. We hope that you've enjoyed this look at transboundary data demands in the 21st century. We want to, again, thank Greg Nojeim from the Center for Democracy and Technology.